Crawford and Stedmer Proprietary Limited is an adverse action case where the store manager of a lingerie store put in a complaint about one of the directors who had brushed his leg against her leg at a work dinner and had invited her out for a separate event afterwards. She'd refused, and when she'd contacted him for work purposes the next day, he was quite rude to her and called her a little slut. So in this context, she ended up putting in a general protections claim because she was ultimately on a contract that wasn't renewed, and she said the reason for that was because of her complaint which was made about this situation in the workplace.
The manager's evidence in relation to the reasons why that a new contract was not offered was ultimately wouldn't say not accepted by the court, but not considered enough to discharge the onus. I think one of the onus which lies on the employer to show that there was a legitimate non-unlawful reason for the termination. I think one of the interesting aspects of this case is that under the general protections, the exercise of workplace right by either making a somewhat frivolous complaint can still provoke the jurisdiction. This case wasn't a frivolous complaint. It was quite a serious matter in terms of the sexual harassment involved. And you do wonder whether, on some level, that works on the mind on the judge, if you know what I mean. Because we have a situation where someone makes a more minor complaint or a non-valid complaint, a complaint that's not substantiated. Often in those cases, there's no doubt that they can, if that is the reason for a termination or an adverse action, that does enliven the jurisdiction. But judges are, after all, human people, and you've got someone who's been subjected to sexual harassment, then not had the contract renewed. They're going to be querying the conduct more than if it is a person, in my opinion, who just put in a more frivolous complaint.
Yeah, and in this case, the female employee made a complaint to the HR manager about the managing director's conduct. She promised that she'd followed it up and apologised, and subsequently did nothing. So it was hard for them to turn around and say that, well, we didn't terminate the contract because of the complaint.
Yeah, and one of the real factual difficulties is the HR manager was trying to say she'd never spoken to the managing director about the complaint, when in fact the evidence showed there had been conversations very soon thereafter, and the judge just couldn't believe that she wouldn't mention this complaint.
And if you get a complaint of this nature, as the HR manager, as any senior person in an organisation, you have to investigate and deal with it. And it's a very risky and unfortunate process that if you don't. If this company had properly investigated it, and if in fact it had nothing to do with the reason for non-renewal, they really should have set out the actual reasons for non-renewal in a pretty clear way so they had something to rely on when it came to court. Because, as I say, it can often be the case that it is quite a legitimate termination, not in this case, or a legitimate non-renewal. But if you know, because there's been a history, a complaint, etc., if you know that there's a risk, you have to make sure that you are very clearly able to establish to the court the other lawful reason for the action that you're taking, in this case, non-renewal.
If you've got some sort of contemporaneous documents, whether it's emails or something else, and evidence of conversations that took place to probably look into something, or the actual reasons for the dismissal, then you're much more likely to end up in a positive situation. Unlike here, where it was found adverse action was taken and the parties were directed to agree on what the compensation should be.
Yes.